This is the current federal tax developments for the week of March the 10th, 2025. Current federal tax developments are brought to you by your state society of CPAs. And we're going to look at a few cases this week, things that happened. So we'll take a look at those items right now. We will start out with discussing a continuation of what we discussed last week. On Sunday, actually, is what hit the Treasury's website last week. We had another change. This one, probably the biggest one we've had to date, in the status of the Corporate Transparency Act reporting. That will mean, presumably, that most of your clients can ignore the reporting at this point, at least for now. We're also going to have a case, Martino versus Commissioner, that looks at the continuing issues for alimony deductions. Now, we all know that the Tax Cuts and Jobs Act took away the ability to have deductible alimony in your divorce settlement. But we also know that pre-2019 decrees, those still can have it, so the alimony issue still shows up. So we're going to talk about an 11th Circuit case in that regard. We'll talk about the estate of Kalikow versus Commissioner. That is an estate tax question that involves settlement payments paid from a Q-tip trust. And we'll talk a little bit about the unique details of that case. And while the tax court and the Court of Appeals have agreed that, in fact, the estate does not get any sort of reduction in the value of the included Q-tip assets, merely because the estate, or basically the trust, made a settlement payment. We'll talk about the unique nature of that settlement that may have a significant bearing on how this decision finally came down. We'll talk about the appeal of A. Markowski. Now, I know this is federal developments we're talking about here, but this actually is something that Congress could control but doesn't. We're going to discuss about when exactly you might decide, your client may discover that the state of California might come calling, asking for them to pay taxes on services they did, even though they never set foot in the state of California. In fact, have never set foot in the state their entire life. It's fine, but it doesn't stop you from paying taxes to the state of California. We'll talk about the CF Headquarters Corporation versus Commissioner case. This looks at taxabilities of grants received for 9/11 relief. Takes quite a while for things to work through the courts, but we've got that. And finally, the United States versus Gora, IRS levy enforcement, and how the tenant in this case apparently figured that she could just tell everybody she was paying somebody else. In essence, it's kind of an interesting case. Weirdly enough, it ends up with the person who owed the IRS money and who had the rent payments from their tenant basically levied, ends up on the side of the IRS in this case and testifies for the IRS. Because, it turns out that the tenant in this case, as we'll discover, was not paying anybody the rent. And she was telling her landlord, hey, I'm not paying you the rent because the IRS, I'm paying it to the IRS. And she then tried to argue the IRS that she didn't really owe the levy, which would mean she probably owed the rent, which means she's lying to the landlord, which, as you might guess, her believability in testimony kind of fell apart in this case. So we'll talk a little bit about that as well. So let's go on to what the big thing was that occurred basically a few hours after I recorded last week's update. Now, the beginning of it apparently took place before I recorded. Apparently, there was a back and forth on X that involved Elon Musk in the beginning. Eventually, there were posts made to Truth Social, and then back on X again that started saying this was going to happen. But it wasn't until Sunday evening that Treasury posted a news release. So we'll talk about what did they say, what's happening here, and what exactly was going on. Well, the big thing that happens with this is, and this was Treasury Department announced the suspension of enforcement of Corporate Transparency Act against U.S. citizens and domestic reporting companies. And this was a press release that came out on March 2nd. And it's on the Treasury Department's website. Now, the interesting aside, we've had three big developments recently involving the Corporate Transparency Act. We had the lifting of the injunction by the court in the Smith case, and the initial response of that by the U.S. government was found on the FinCEN BOI page. We then had a later clarification, that in fact, we were going to be, officially you wouldn't have to file by the March 21st date. That there would be a new rule coming out and there'd be more information. That was posted on the FinCEN main site, but not on the BOI page. And then finally, this one, which tells us for the most part we'll be able to ignore the BOI filings for domestic companies and U.S. citizens, that ends up being posted on neither FinCEN site, but on the main Treasury page. Okay, you take a look at stuff like that and you begin to think that there are, as one person phrased it, too many cooks in the kitchen. There appear to be a lot of different inputs here and potentially a lot of disagreements about exactly how to handle things. So it's messy, shall we say. So keep your eye on this. But the key takeaway right now, though, is key. As the March 2nd notice said, issued by the Treasury Department, and which quoted the Treasury Secretary. So we're going to go with that because the Treasury Secretary outranks the head of FinCEN in theory. So, we should have, in essence, going by that. That Treasury will not enforce any penalties or fines against U.S. citizens or domestic reporting companies or their beneficial owners concerning the Corporate Transparency Act. Now, it's interesting because, of course, it talks about some other issues. And it also goes on and says that they will issue a proposed rulemaking that will narrow the scope of the rules to foreign reporting companies only. So it's interesting in that regard. Now, we do have definitions of a foreign reporting company, but those are found in the final rule. They are not found in the text of the law, meaning that Treasury could, because they're going to issue a revised final rule, they could change that definition. And it would be consistent with this, but, it'd seem a little weird. I'm going to go, at least for now, on a 99% assumption, holding back 1% because it could say they literally never said they wouldn't change it. But I'm going to go with the 99% rule and saying that a foreign reporting company will be what's defined in the final rule we have now. They could change it, though. I mean, theoretically, they've never told us they wouldn't. So sometimes when you read these releases, especially when you have disagreements that appear to exist, internally in the agency, you sometimes have to be very careful not to overread something or try to figure out how could somebody else come in, change something, and be able to say we're not being inconsistent, things like that. But let's talk about this particular program. As they said, they tend to issue proposed rulemaking, and again narrow the scope of the rule to foreign reporting companies only. That foreign reporting company is defined, but importantly defined in the final rule, not the statute, as a company formed under foreign law, non-U.S. law, and registered to do business in the U.S. with a U.S. state or territory. That's our definition, or basically, or an Indian nation. Any one of those will count you as a foreign reporting entity. And apparently the reporting we're looking at now will be those of foreign reporting companies only, and it will be their basically beneficial owners, which may or may not include U.S. citizens. That's also not clear from this. I mean, the news release does say U.S. citizens won't need to report, but it seems a little weird that one of the suspicious things somebody could do if you're trying to launder money and set things up would be to set it up as a foreign company, a foreign entity, right? Or let's say one of those things. And so you'd think that those people would need to be identified. But again, we're all speculating until we actually see the proposed rule. And the proposed rule, there's no guarantee except sometime this year when we're going to see the proposed rule and, what's going to be in it. So for right now, as I said, everything we're going to say here, we've got it on a press release right now. Technically, a press release does not have force of law, but presuming they're not idiots, right? Because it would be kind of political suicide to put that out and then say, oh, sorry, the rule was this, you just didn't follow it. Yeah, it would seem a little weird to go down that path. So we're going to assume that, yeah, this is the direction we're going, right? It would make sense. But we don't know what's going to be in that proposed rule. And I'd have to say, because it's not out yet, there's at least some, yes, it would take a little time to draft it. But you would think, in theory, this administration has known, since January 20th that they did it. And yes, I realize our Treasury Secretary didn't get confirmed until recently. But again, it would seem like the language should at least have some basic version going. So hopefully we'll see it soon. We'll phrase it that way. Now, this does leave some lingering questions, right? As I said, there is uncertainty remains because we know that the details of that final rule is going to be the key. The law depends on the details in the rule. And right now, because we don't have the rule, it's going to be a little tough for us to say that we've got these details, right? As I said, to me, the one thing I would worry about most is, are they going to retain the definitions found currently in the final rule now found in 31 CFR 1010.380 E1II, which has the definition of what is a foreign reporting entity. As I noted, the statutory text does not have that name. Now, it talks about foreign entities having to do these things, etc., but it never uses that term. So that term is one created by the rule. And as I say, my concern there is because the terms created by the rule, we have to be aware that the rule, we're going to revise the rule. It is possible the term will change. So that's going to be one of the first things we're going to look at when we get to proposed final rule, is to make sure that that definition didn't change. Because those are those entities have to file. And in theory, if you're not one of those, you won't have to file. We'll confirm that too in the final rule. But it'd be a lot tougher, I think, for them to do something that said other entities besides, what will be considered, whatever we define a foreign reporting entity as, have to report. That would be a little tough to say we didn't lie. So in that case, I'm going to say probably the definition of foreign reporting entity will be crucial. I would hope it is the same. I believe overwhelmingly it will be the same. But again, the old line from years ago, trust but verify, from Reagan years. Yeah, trust but verify, right? We'll trust it, but we're going to verify it, right? That'll be the key issue right here. You need to keep informed, right? Keep your eye on the guidance. But it does seem that as we stand right now, everybody except for foreign LLCs, corporations, etc., should be out of the woods on reporting. We will know that for sure. We see the final rule. Actually, we'll know it for sure. Like I said, we see the actual final rule, not proposed, but the final rule. That's when we will know it for sure. Now, one area of concern, which also means we've got to watch it, is remember, none of this currently is changing the law. It would seem to be very helpful if Congress would go in and change the law, if this is how it's going to be interpreted, because the bottom line is, because it's interpretive, remember, we're back to Loper-Bright type situation, and I'm not sure who would have standing to challenge this, but it seems possible law enforcement, any law enforcement agency may have some challenge because they would have access to this data. And of course, if they're not reporting, there'll be no data to access, and it would seem like they might have it. And now we get into, will this reg be subject to challenge? And then number two, even better, could this reg be changed by a successor administration? In which case they would say, well, our reg actually follows the law, unlike this prior one. That's the danger with Congress not touching and fixing this. So be aware of that. Keep your eye on what's going on, and it could be for any reason. Something could happen, that could make it very, very, now suddenly we're very negative on these hidden ownership things, and that law is already there and could change instantly. So I would really like Congress to change the law if we're going this route. I just don't want it to be so quickly able to be reestablished. And everybody's saying, well, the law has always said you had to do that, right? I know, but you told us we didn't have to do it. You shouldn't pay attention to us, I guess, would be the issue. That'd be our concern. So, bottom line, this news release expands on the February 27th announcement, right? It does say very clearly they will not issue fines, penalties, or enforcement actions for failure to file or update the reports by the existing deadlines. Now, I would say that is within FinCEN's powers. Why? Some people are saying now it's not. I'm going to say the catch is that the penalties are up to $595 a day. To my theory, read literally up to does include zero, right? Zero is a penalty up to $595. So in theory, FinCEN could just impose a $0 penalty. Now, whether they can do that by regulation is a different question. I think that gets tougher as to whether by regulation they could say the penalty will never be more than zero. That's why I do agree with some comments I've seen that said the smarter thing to have done would have been to just, put out announcements, things like that, and just issue this guidance saying that, our penalties are going to be zero for the foreseeable future, as opposed to trying to go the regulatory route, especially post-Loper Bright, where I think it's going to be tougher to argue that that reg meets the statutory interpretation part of the theory. Rather, it is prosecutorial discretion. But prosecutorial discretion really probably shouldn't be written into a reg, right? The idea is discretion of the prosecutor, but that's a different issue. Now, the current not issuing penalties will be in place till an interim final rule extending the BOI reporting deadlines becomes effective. And they do tend to solicit public comment. That was part of the February 27th announcement. So this does flesh out some of that. So bottom line, where are we at right now? As of this moment, nobody needs to file anything by March 21st, at least assuming we don't get a lot of guidance out very quickly, which seems highly unlikely. When the March 21st date comes in place, then penalties will still not be required until such time as we get further information from FinCEN, right? So in essence, we'll have an interim final rule. That's like a temporary regulation. That will probably be the first implementing part of this. That will tell us, who are the foreign entities that need to file, what's their new deadlines, etc. You do want to review that because A, you want to make sure no entity you deal with is a foreign reporting entity, and number two, to make sure, that we haven't seen any changes there. And then there will be a proposed final rule. And we need to check that one too when it comes out. But as it stands right now, overwhelmingly appears to be the case that we are not going to worry about this filing anymore, at least unless you have a foreign entity. So, as I said, it's been a very interesting roller coaster ride. I would like the law changed so we can't get back on the roller coaster. If we actually are going to take this out, then let's go that route. Whether it could pass Congress is a different question. And as I said, post-Loper Bright, that may be more of a concern. Where the courts will say, well, if Congress won't pass it, then obviously the regs, then the reg's improper, in essence. So, Congress should be the one to do this, not the executive branch. We'll hope. We'll just have to watch. But again, first, you got to find somebody that would have standing to come to court. And that's usually the interesting aside we get with court cases and things like this. Okay, next up, let's revisit the fun part of alimony. Right, alimony. This is the case of Martino versus Commissioner, the 11th Circuit, case number 2411438. The decision came down on March the 3rd. Okay, this is a case of an alimony and kind of a delayed payment problem for this case. Okay. So, at the end of the day, the 11th Circuit will uphold the tax court's decision that, in essence, none of Joseph Martino's alimony deductions claimed for 2017 and 2018 were allowable. They did not meet the definition of what is alimony. Now, as you may recall, we have some interesting issues here of, what is alimony and how it works. Generally, alimony has to meet the federal definition, right? Now, we know that currently that's gone from the code. So you have to go find the Section 71 that existed before the TCJA came into play. And you usually discover that there is, a set of tests. It has to be according to divorce agreements, has to establish it, right? The payments cannot continue beyond the death of the recipient, would not have to continue beyond that date, right? That'll be part of it. We have to also make sure that, it's not child support. And we also have to make sure, that the payments in this case were never labeled as amounts that will not be considered alimony that is taxable to the recipient and deductible by the payor. And those are all things that are part of it. Now, in their divorce years ago, Martino and Roberts, the former spouse, reached a settlement agreement. One of the big things in here, in fact, by far the biggest, was that there was going to be payments that generally for a non-taxable equitable division of marital property. And one of the big things in here was that Martino, the taxpayer in this case, was to gain sole possession of their house in exchange for a $2.2 million payment to his ex-spouse, right? He was also going to pay $3,000 per month as taxable periodic alimony. Now, this was a settlement agreement. The divorce decree incorporated the agreement, right? That would be part of what went on. Now, there were some payment problems and issues, so further litigation took place. And eventually, a consent order modified his obligation for the payment for the marital residence to be $3.5 million paid in installment. And that consent order reiterated these payments would be tax-free to his former spouse, right? Okay. Now, after he failed to make an installment payment, the court issued additional orders and contempt orders to enforce the payment schedule, including directing Martino, to essentially provide a payment, to pay and provide a payment and provide Roberts a deed to foreclose on the residence. Now, he eventually filed for bankruptcy, and while the marital residence was sold, the proceeds did not go to Roberts. And so Martino still had a $3 million obligation, which was considered non-dischargeable. So now the property is gone, which he was going to pay her for, but it was a non-dischargeable payment after the structure they had. So it couldn't be discharged in bankruptcy. So now Martino owes her $3 million. Okay. Well, at this point, the court had a revised payment schedule. It directed Martino's insurers to withhold the $25,000 monthly payment from disability insurance distributions. He was disabled, so we're getting that now. And it was to go for the previously owed arrearage to his ex-spouse in the amount of $3 million plus interest. Now, those payments will be applied first to other outstanding debts per the agreement, including past due alimony, child support, and uninsured medical expenses. Right? By the end of 2016, these debts were discharged, and subsequent payments were just to be applied to the $3 million marital residence debt. So, get here to the end of all this. We're now down with that. That's our structure we're looking at here. So remember, the question is 2017, 2018. They're still taking this $25,000 out of his, they're taking $25,000, the insurers are, out of his disability insurance payments being paid to him and sending it to his ex-spouse. Now, Martino is going to claim that this represents alimony now. It's periodic payments of alimony. And the courts are going to have a little trouble with this, but he said he should be entitled to, in this case, in the years in question, $300,000 of alimony deductions for each of 2017 and 2018. He said these orders contain no statements that the payments were not alimony or the payments would not be treated as income to his former spouse. These are the income deduction orders from the court. He's saying, hey, it never said this $25,000 payment they're taking out of my disability insurance, that is, being redirected to her, my income being redirected to her, that was not taxable to her. So he's saying, hey, missing that, and otherwise all the clauses work. At least his theory is all the clauses work. So let's go to see, did the court buy this? Well, what the court found was essentially, right? The question was, they said the divorce instruments contain multiple designations stating the payments for alimony. And the court said, you take all of these as a whole. None of them have to say word for word, the exact language found in Section 71B1 of the Internal Revenue Code, that essentially said it's not taxable under the specific IRC section. The original settlement agreement was very clear. These payments were a non-taxable, equitable division of marital property. That was clear. That included the payment for the house, right? Which at this point is the one remaining debt, right? It was the $3 million that he owed. He had to pay her for the house on the, the levy against it that he had to do. So she had a lien against it for $3 million. He had to pay on that. And that was really continuation of the property settlement. They said, and they say it is because you don't just take that one document that he's paying $25,000 on in isolation. You look at the entire history of what led up to that. And the court said, it's very clear. That was meant to be the property settlement. It was never intended to be the alimony. Yes, it could have paid alimony, but everything related to alimony was discharged by the end of 16. So all payments in 17, the only thing remaining that he was paying on was the property settlement. And the court did reference Section 71H, 71B1B, form of this case, and it said, as long as these agreements in general, and they say you take all the agreements together, it designates such payment as non-includable in gross income and not allowable as a deduction, that was good enough. It said, yes, they didn't have that word for word, but the implications were clear, and none of this changes that. So, gang, sorry, sir, but you're not going to get a deduction. Next up is the estate of this case, Kalikow, right? Kalikow, I guess it is. Pearl Kalikow versus Commissioner. This is a Second Circuit Court of Appeals case. Case number 237957, that was decided on March 4th. And this is the question about the value of the assets, including her estate, under a, Q-tip trust. So the Second Circuit affirmed the tax court judgment that the settlement liability did not reduce the value of the trust assets that had to be included in her estate under the Q-tip arrangement. Okay. Now, what brought this up is something that, unfortunately, we've seen a number of times in this type of background. So, Pearl was the beneficiary of a Q-tip trust, the SK trust, that was established by her deceased husband, Sidney Kalikow, right? Now, this SK trust consisted primarily of, I believe it was 10 income-producing rentals, right? So in essence, right, it had 10 rental properties. They were inside the Q-tip trust. By the terms of the trust, the income from that trust would be payable to Pearl for her life, right? At her passing, the trust then would go on to the kids. And again, because presumably they already had fully funded a bypass trust, they made sure that in this case, she made the Q-tip election, right? In essence, because otherwise, the reason you make Q-tip election is you have a trust that would otherwise, in this case, have qualified as a bypass, which would have meant, it would have been excess amounts transferred at the first death. Remember, because we do a bypass trust in order to treat these as transferred at the first death, but still have income surviving spouse. So now we've got the rest of this. So, to allow her to still have income from these 10 rental properties, but treat them as nevertheless not being transferred at her husband's death, because then there would have been a tax to pay on the estate. They treat it to include it in her will, right? And the will directed the trustee to pay the trust net income to Pearl at least quarterly. And again, upon her death, the remaining property was distributed evenly between two trusts for the benefits of Sydney and Pearl's children, which was the children's trust in that case. Okay. And otherwise, Pearl was giving the residual of her estate was given to charity. Keep that in mind as we look at this, because it is an interesting set of facts. Okay. Now, what had happened was that even on large estates like this, people sometimes don't necessarily follow the trust agreement perfectly. In this case, there was a dispute because the trustees had failed to distribute the full amount of income generated by the partnership to which Pearl was entitled to Pearl. Now, that's important if you are a beneficiary of Pearl, but not a beneficiary of the trust to which the Q-tip funds will go. And in this case, there's at least one charity that might have raised that issue. There certainly were various things going on regarding that, but it had failed to pay over, right? It failed to pay over the income. So that income should not have been in the Q-tip trust when Pearl died. Those assets equal to that income number should have been transferred to her personal ownership and therefore would have presumably ended up being part of her estate at her death. So that's kind of what it is. And, so they agreed to a $6.572 million settlement payment from the trust to Pearl's estate to resolve the claim, right? And the trust and the children's trust were jointly liable, right, to pay that claim. As I say, again, right, you understand that problem. We often see that. Remember, in the state, it gets messy if, when you have this division at the first death, if the beneficiaries of the surviving spouse are not going to be identical to the beneficiaries of the trusts that have been set up. In that case, yes, a failure to pay the income over that the trust is supposed to pay over to the surviving spouse, in addition to creating other problems that we won't go into right now, it does create the problem that you're setting up potential litigation at the death of the surviving spouse, because assets are either they have overpaid assets out of there, and so she got a distribution into her estate that should have stayed in the trust, or what's more difficult to defend, because she always could, usually there are invasions for some reasons allowed, so the trustee could defend invading corpus in some cases, especially on a bypass trust. What's tougher to defend is not taking the income. That income's supposed to be taken. Now, she could formally, I guess, disclaim but that's not what happened. They just kind of ignore that, and they just treat it as, we write, we'll write a check over to Pearl if she needs some money to pay for something. And it becomes this, so that trust ends up with assets it should not have, which was happened in this case. But our key question is going to be now, very simply, does that mean that the value of the assets in the Q-tip trust that will be reported on Pearl's 706 should be reduced by this $6.572 million settlement? And the tax court said no. And the Second Circuit agreed. It said the issue is this settlement liability did not reduce the value of the assets in the trust, and those assets had to be included in Pearl's estate. The court said the trust was a separate legal entity from Pearl's estate, right? The trust was separate. The estate had a right to assets in the trust. So the trust was some assets in there. It had certain rights there. It's a separate entity. The liabilities did not encumber the assets. The assets still got transferred, right? And the settlement payment would be subjected to a charitable contribution deduction. Again, yes, Pearl might have, they said, look, she's still going to get a deduction over there, so it's not double taxed, right? Because we're not going to tax it, twice, is what they said. It got rid of that whole theory of double taxation, because only the underlying assets would be taxed part of her estate. The settlement payment is part of her residuary estate, which she bequeathed to a charity, the Sunshine Foundation. The estate gets a charitable contribution deduction for the amount of the settlement payment rather than it being taxed at all. Nobody got taxed on it. Okay. Now, that was kind of a useful fact the court pointed out. But the real problem here was, of course, the nature of this, when there is a failure to pay, money from the survivor's trust, I should say the Q-tip trust, to the estate of the surviving spouse, it really wouldn't work well, if we could just take that out of her estate. That seems counterintuitive, because whether it had been paid to her, it was now sitting in her account in her name in her estate, or it's sitting in, the Q-tip trust, it's still going to be subject to her estate, right? So it's part of her taxable estate. The theory being, it doesn't matter in this case. The tax court said it doesn't matter. That's how we deal with this. So, that's kind of the way it would go. Next up, we're going to talk now about a slightly different thing than we usually do. And this is the Office of Tax Appeals of the state of California. And this is the appeal of A. Markowski. This is the OTA's case, right? Number 210-67902. Decision was released on March 3rd. Actually, was given to Markowski a long time before that, but it took a while to get in. Now, the Office of Tax Appeals, which is who hears appeals from the Franchise Tax Board in California, considered, basically they heard the appeal of the Franchise Tax Board's denial of a refund claim he had for his 2017 tax year. So the key issue here is, did Markowski receive taxable income from a California source in the 2017 tax year? Now, as I said, the reason why we're going to consider this a federal issue is because this right now falls under effectively the Dormant Commerce Clause coverage systems. And that is what exactly the Commerce Clause of the U.S. Constitution, which the Supreme Court has pointed out in sales tax for sure, and there's no reason it wouldn't apply to income taxes, allows U.S. Congress to limit what the states can do regarding interstate commerce, which includes taxing items that are part of that. However, Congress has generally failed to act. Public Law 86-272, which is the only thing they've really ever passed that actually deals with, and in that case, income taxes. They haven't, and that was supposed to be a temporary bill that was that was enacted decades ago. It was supposed to only last 6 months. So Congress doesn't like to touch this because it gets in a very touchy area, and obviously the states get mad if you limit their ability to tax things. So that tends to be where we get touchy and why they have it. So since Congress has not taken on the responsibility of actually deciding these things, we end up with the Dormant Commerce Clause applying, which is where the Supreme Court steps in and decides that something is kind of like inherently against the idea of the Commerce Clause. Remember, the Commerce Clause was enacted as part of the Constitution, put into the Constitution, in reaction to the chaos that existed under the Articles of Confederation, where states would like impose tariffs and other taxes on anything coming in from another state, which then created, kind of a nightmarish scenario of you couldn't sell anything outside your state, that they would advantage the inside the state companies. Okay, well, now we're going to apply this to income taxes. And the question in this case becomes, Mr. Markowski had certain facts in the case, right? Now, he was a computer coder. He wrote computer codes for Derivative Technology, LLC. This was registered with the California Secretary of State and was located in San Mateo, California, on the northern part of the Silicon Valley. South of San Francisco, right? North of places like Palo Alto, etc. So it's sitting right in there in the, in basically on the West Bay area in San Francisco, over there along on the southern peninsula of the San Francisco Bay. So, but he didn't go to San Mateo, California. He didn't go to California at all. He did all of his work in Connecticut, where he lived. He has never been to California. However, Derivative Technologies issued a 1099 miscellaneous to Markowski and reported $37,057 of non-employee compensation for 2017 tax year, and they filed that document with the Franchise Tax Board as well. The Franchise Tax Board starts looking for Mr. Markowski and indicates that he owes tax. Now, the problem with this is normally by the time the FTB gets into this and starts trying to assess the tax, we're quite often, outside the statute of being able to claim a credit for taxes paid to another state. So that's the big problem of discovering that your client, let's say your client's sitting there in Connecticut, you thought, hey, he's in Connecticut, he's doing all of his work in Connecticut, all of his income is from Connecticut, so only a Connecticut income tax return is prepared. The problem is, if in fact there is another state that is able to successfully tax him, if your statute's closed, which it almost certainly is by now in Connecticut, we're getting a credit for taxes paid to California. And in vast majority of cases, except for the states of, Oregon, Arizona, Indiana, Virginia, aside from residents of those states, your credit's going to go on the state you live in. Those states and California have a really weird set of rules that give us backwards credits. Don't worry about that if you don't deal with those states, because you have to live in one of them and have income from another. And then the backwards credit problem comes up. Those of us here in Arizona know all about the backwards credit problem. Those in California, Oregon, etc., know about it. Virginia runs into it less often because the other states aren't nearly as close, and Indiana, the other states aren't geographically really close to them. But out here, Arizona, California, Oregon, we run into this issue with a regular basis, shall we say. We tend to have it. But that's not your problem here. And the interesting part about the backward credit is there it actually doesn't matter, because the credit would end up on the California return, credit for taxes paid to Arizona, and those taxes were paid timely, so we're good. But that's going to help Mr. Markowski, because he doesn't live in Arizona or Oregon or Virginia, right? Or Indiana. He lives in Connecticut. So the real question was, he reported his income on his federal return. He did not file any tax returns with the state of California, believing, I did all of this in Connecticut. Why would I owe tax to California? And if Mr. Markowski had been an employee of Derivative Technology, he would have been right. He could have done this coding as an employee of Derivative Technology, and he was in Connecticut. California would not have taxed him. Now, don't say that means no other state would tax him. If he'd done work for a company in New York as an employee, yeah, then we get into a whole nother mess called the convenience of the employer rule that New York applies. Different rule. But California says if you're a sole proprietor, that's a business operation, and we don't apply the employee style rule. Rather, we apply a business rule. And not necessarily the one that you might get from reading right away, because California seems to have a pretty generous exclusion of, well, sales don't count to get over $500,000, as I recall. Except the law is written weirdly, and there is a second way in, which they use in this case, right? What they said was that Mr. Markowski, right, essentially received taxable income from a California source, right, in this case. And what they ruled was, the sourcing options, if you have a trade or business, right, that you carry on as a unitary business within and without California, you must apportion the income, right, in this case. And this requirement is found in Regulation 17951-4C of California's basically Revenue and Taxation Code. You find that, you've got it. It's where it's at. Now, the catch there. The taxpayer must be a non-resident for this to apply. The taxpayer must be conducting a business of sole proprietorship. The taxpayer must be carrying on a unitary trade, business, or profession, as grouped as a whole. California parts as part of that unitary operation. And the taxpayer's unitary trade, business, profession must be conducted within and without California. Now, you might think that fourth option, covers it, right? Because he only took place outside of California. But the problem is the business was, and the benefit of the work he did was received in California. This is going to be basically using, which by the way now a majority of states use, market-based sourcing for services. This is an apportionment calculation that gets triggered. California views it that way. And when we look at market-based sourcing, well, his sale, he was selling in California. That means his business was taking place inside and outside. Inside California, where he got the sale, outside California, where he was performing the service, right? So they said, look, he is the sole proprietorship, right? He's not an employee of the company. Nobody seemed to claim he was, right? And he reported it on Schedule C. Now, he tried to argue that, wait, I should have been an employee of Dynamex, employee according to the Dynamex case from California from 2018. But the OTA found he didn't provide evidence that he was an employee. And he said, that the FTB is not the hiring entity in this case, and so can't be placed in the same position as a hiring entity. So he tried to say he was an employee. He said, shows a derivative, it's unitary business. There they found the evidence showed Derivative Technology hired Markowski to write computer codes in his capacity as owner of a sole proprietorship, thus to conduct a one-service business which he controlled as managed. As far as the OTA could tell, the business was interrelated and interdependent, employing and consuming the same resources. Therefore, the third requirement was met. And now the final question, did he have business within and without California? Right? It shows that Markowski received income from Derivative Technologies and LLC located in California for services rendered as sole proprietor. Even though he said he did not conduct his business in California because he never was physically present in the state, the statute does not require physical presence in California to impose a tax. When he performed services in Connecticut and derived California source income from a company located in California, he said essentially that was carrying on a business, because the catch is going to be the source of the income is going to be the issue here. Where was the benefit received? And the benefit of his coding work was received by the customer, Derivative Technologies, inside the state of California, right? So basically, and the reg 25, or I should say, California Reg Title 18, Section 25136-2C2, there's a cascading set of rules to determine where benefits are received. A, the location of the benefit services shall be presumed to be received in California to the extent the contract between the taxpayer and the taxpayer's customers or the taxpayer's books and records kept in normal course of business, notwithstanding the billing address of the customer, indicate the benefit of the services is in California. Now, the court said, or OTA said, okay, nothing in the contract or the taxpayer's books really, directly talks about, the services being received in California, right? If neither the contract nor taxpayer's book and record provide a location where the service is received, right, or the presumption is overcome because age is presumption, then location where the business received shall be reasonably approximated. And if it cannot be reasonably approximated, then the location shall be where the benefit of the service is received, shall be presumed to be in this state, California, if the location from which the taxpayer's customer placed the order was in California. And if you can't do any one of those don't work, then the benefit shall be in California if the taxpayer's customer's billing address is in the state. They said, okay, A doesn't work, right? Under B, they said they reasonably approximated the service location where you see the benefit means in relevant part. They considered all source of information, said, hey, they're located in San Mateo, right? This is coming to them in San Mateo where they're incorporating it into the project, right? He's doing the coding, right? It received the benefits of those services within California, and that meant the entire amount of income he received was sourced to California, which means, hey, Mr. Markowski, you owe California money, right? Since he was conducting as sole proprietorship, his business was unitary within and without California, and derivative received the benefit within California, he had to pay to the California Franchise Tax Board. This has come up now. California has done this because they won a few years ago against an Arizona writer who had been employed. I believe it was in the basically in the entertainment industry. He had been tasked to write a script or whatever, and they got him. He was only in Arizona. They picked him up there. I have talked with a firm before who in that same time frame that came down, the Arizona case came down, had a client on the East Coast who had been writing like a human resource manual for a county in California and got tripped the same way. The FTB will come after this. But remember, there are 49 other states, right? And some territories just for fun. You could find this coming up a lot. It is becoming more interesting. As I said, for employees, most states only consider where the employee is actually physically performing the work, but most does not mean all, with a huge exception being New York and a couple of other states where you get this convenience of the employer rule. State taxation is messy, and especially where services are involved. State income taxation. So, take care, keep your eye on this, but especially be aware because the Franchise Tax Board in California is definitely looking for these cases, right? It's come up too often. So we definitely have a problem here with the Franchise Tax Board. Next up is a taxability of grants cases, CF Headquarters Corporation versus Commissioner, right? This particular case is a reported tax court case, 164 TC number 5, on March 4th of 2025. And this was a question whether a corporation had to include over $3.1 million of grant proceeds related to 9/11 relief had to be included in its gross income for 2007. That was its takeaway. Okay? This is a program that was established by New York State following the September 11th, 2001 terrorist attacks. The grant program was to aid affected businesses, right? In 2007, they received a grant under one such program, right? These were intended for specific expense categories, including rent that CF headquarters companies, basically items that they had been involved with. So essentially, this is kind of where we end up here, right? So it was like rent, et cetera, expenses they incurred. It was to give them money for this. Now, CF headquarters took the position that this was a non-taxable receipt, basically for public benefit, et cetera. The court really didn't agree in this case, right? Number one, the court notes, as we always start with analysis of business income, you always start in Internal Revenue Code section 61, specifically 61A. Gross income is all income from whatever source derived. That is your definition. And then you have to find a specific exclusion. All exclusions are construed narrowly by the courts, right? The court did not agree with the taxpayer's reliance on the case of Edwards versus Cuba Railroad from 1925, noted that its effect had been reduced dramatically by later Supreme Court decisions. It said, so basically, this $3.1 million of income you got from the state of New York is taxable unless we can find a section to exclude it under. We can't do that, we're in trouble. Now, the taxpayer tried to turn to previous version of Section 118, which was contributions to a corporation's capital from gross income. They're excludable. That includes those from non-shareholders. But it noted, the court did, that even under the prior version, that version has now been tightened up quite a bit. Exclusion does not apply to money or property transferred in consideration for goods or services. And citing United States versus Chicago, Burlington, and Quincy Railroad, 1973 Supreme Court case, it stated the transfer for, stated that for a transfer to qualify as contribution of capital, the transferor must intend it as such. And the court had 5 characteristics, including whether contributed assets become part of the permanent working capital. And that wasn't the case here. They're reimbursing specific expenses. They also consider commissioner versus broker tax holdings, where the Third Circuit held a relocation inducement must become a permanent part of transferee's working capital to be considered contribution of capital. Tax court found these grant proceeds in this case were intended to reimburse for rent expenses and so did not become part of their working capital permanently, finding that was not part of it. Okay, next, it's a gift under 102, right? Section 102A excludes from income any gifts. Transfers by gifts are excluded from gross income. And determination whether a transfer is a gift depends on the transfer's or I'll get the words out right here, intent. What was the intent of the state of New York? Now, citing Commissioner versus Duberstein, another Supreme Court case from 1960, it was noted that a gift must proceed from detached and disinterested generosity. In this case, they found that New York's motives was not detached generosity, but the pursuit of increased employment commitment from those receiving the grant. They also reviewed the funding legislation and the legislative history of this thing, and they said that it did not possess the requisite donative intent. The court also stated that Section 139A. So finally, the taxpayer turned to Section 139A. A payments made as a qualified disaster relief payment. Very quickly, the Second Circuit got rid of that one, noting 139A only applies to individuals, not to corporations. This corporation cannot qualify under those rules. Okay? So in that case, because of that. Now, the final question came down to, is there a penalty here? And the court did find in this case that, there was substantial authority for their treatment of the grant proceeds, and the petitioner was not liable, therefore, the accident-related penalty under 6662. It said, based on Supreme Court decisions, statutory text at 118, and regulations thereunder, they found substantial authority. This is interesting because this is one of those rare cases where the court will find they didn't say it was reasonable cause. Basically that there was, reasonable care, etc. That wasn't, they got bad advice. They said that, in fact, the position met the substantial authority position, which is, as I say, that's unusual. Usually we look to, they got bad advice. They're not saying the advice is bad here. They're saying that the question was open enough and what they had met substantial authority, even though the court did not agree that authority, in the end, bound the court to find it was non-taxable. So that was kind of interesting. The key takeaways from this, remember, you always have an uphill battle trying to say something's not taxable. You have to find specific authority. I think that was a big reason why these people didn't get penalized. They had done their homework and had authorities. Now, the court didn't follow those authorities. I think especially 118 was the one I think the court spent the most time on looking at. They actually said, but given all of that, at the time, the then 118, they were okay with it being there. But you got to find something. You got to have something to exclude it, not just, this isn't fair, is not really going to get you anywhere, right? Or Congress probably didn't mean it to be also to get you anywhere. All exclusions from gross income are construed narrowly. So you really got to make sure it's not just arguable you're excludable, but that it's solid, right? We're not trying to expand a definition in any way, shape, or form. And also remember that qualified disaster payments, 139A, is not going to help you if you're not an individual. If it's not an individual taxpayer, 139A's qualified disaster payments don't help you. Corporations cannot deal with that. Okay, our final case for the day. We're going to take a look here at a district court case in Minnesota, the United States versus Gora, right? And the question here becomes, this is U.S. District Court, Minnesota, case number 21CV2172. And this came down on March the 6th. This is the United States action against, in this case, Joni Gora for failing to comply with an IRS levy to pay her rent payments to the IRS that were due to her landlord, who was having problems with the IRS. Right? That's kind of the case overview, what was going on. Now, the Olsons were her landlord. They owned a property in Iota, Minnesota, which she rented starting in January of 2019. And on September 23rd of 2020, the IRS issued a notice of levy to Ms. Gora, the tenant, to collect the monthly amounts she owed to the Olsons were to be paid to the IRS. The question in this case becomes, she didn't pay rent to the IRS after receiving that levy, but it was even a little bit better than that. She also didn't pay rents to her landlord. Because when I first saw this case, it's like, oh, what was it like? She's related to him or something? She stashed the money under the table. What was going on? No, it was very simple. She was telling her landlord, I'm not paying you rent because I'm sending it to the IRS. And then she didn't send it to the IRS. Now, she apparently thought that this would all work, right? Her landlord, ultimately, knew that even if he succeeded in forcing her to pay, it would go to the IRS. But she told him she was paying them. So maybe she saw this as a no harm, no foul. They're not getting the rent payment anyway. So why would they care? I'll tell them I'm paying it, but it's not really a problem because they wouldn't get it anyway. And then she just didn't send it to the IRS. And her theories were a little weird about why she didn't have to send it. But what becomes interesting is that Mr. Olson becomes a key witness for the IRS in this case. You might wait, he's not going to get the money. No, he's not getting the money, but he would get credit for what she paid. If the IRS wins and collects this money from her, it will reduce what he owes, right? And, that's basically, as far as he's concerned, a win, right? It reduces what he owes. So unfortunately, Ms. Gora also discovered that there are consequences to not honoring a levy. Right? Now, in essence, the court found that she's liable to the U.S. And a lot of the problems came up with she did a lot of things that really compromised her credibility with the court just hugely, okay? Right? Her lease was a month-to-month arrangement that, by the time we got to September of 2020, it was $1,150. It didn't start out there, but it got to that point over time. Again, she had the notice of levy. It was sent with a cover letter explaining their obligations to respond, and this levy attaches to all future rent payments. Now, Ms. Gora spoke with the IRS revenue officer around October 8th of 2020. She understood she was obligated to make her future rent payments to the IRS. Now, she claims she sent the IRS $1,150 each month for 5 to 7 months, starting October 25th, 2020. However, the IRS never got those payments. She notified her in January and July of 21 they're not receiving payments. Now, she provided the IRS, Mr. Olson, and later the IRS with documents she claims were bank statements showing the checks being cash. But she later admitted these weren't official bank statements, but were personal spending documents. So she said, here's proof I paid it. I wrote a note that said I paid it. After telling people these were bank records. Yeah, didn't really do that. Okay. Now, she claimed that she and her landlord agreed she'd pay rent in cash starting in June 2021. But he testified she did not make a rent payment to him after September 20 payment for October 2020. So after the levy went in place, she never paid him anything. And the court believed him because she had lied, right? She conceded at trial there were no true bank statements. She never got actual bank statements. She didn't try to get actual bank statements, right? Showing payments made after she stopped paying via Venmo. And she paid with Venmo and Cash App, and therefore the court said you had paid before using that. I believe you would have continued to use it. So, we think you're lying that you didn't pay cash, right? And therefore, None of her payments were delivered to the IRS. None of them came out of her account. Now, what she argued was that because she didn't have a written lease, right, when the levy was issued, because no obligation exists at the time of the levy for her to pay rent, or live there beyond the next month, that she was not liable to the U.S. or subject to a penalty. The court didn't really accept that view, right? It says essentially that the fact that it was a month-to-month rent didn't really change anything, right? And there's a long citations they've got. Let's look, and I should go over all of her stuff first, what she said. She then contended it was not legally effective beyond the next month's rent because the rent was issued through the month-to-month nature of the lease. And she said her argument concerning legal effectiveness of the levy to attach to a month-to-month lease constituted a reasonable cause for failing to surrender the property. So what she's saying is, well, it's a month-to-month lease, so you can't levy what I'm not liable for. In theory, stating the IRS have to get her ahead of paying the rent every month and issue a new levy. And then she contended, because, by the way, the penalty for not turning over money that you have due to a levy is 50% of the amount you should have paid the IRS, in addition to having to still pay the IRS the money you should have transferred. So she has to get out of that penalty too if she owes the money. So she's saying, well, her argument concerning legal effectiveness of the levy to attach to a month-to-month lease, well, that was reasonable cause for failing to surrender the property. The court wasn't going to buy any of this, right? As the court noted under Section 6331 of the Internal Revenue Code, the IRS can levy upon all property and rights to property of a delinquent taxpayer. Which states the levy only reaches, and this is Regulation 301-6331-1A, tells us the levy only reaches property possessed and obligations which exist at the time of the levy. And obligations exist when liability obligor is fixed and terminable, although the right to receive the payment may be deferred until a later date. Like they said, the court also noted a pair of cases, one from the Sixth Circuit, one from the U.S. from a district court in Minnesota, noting the service of the notice of levy reduces property or property right to the constructive possession of the United States, and the third party must surrender it. So the minute the levy was issued, that rent payment that she owed every month was the property of the U.S., not the property of Ms. Gora. So Ms. Gora was illegally holding on to government's property. Okay. And of course, there is a direct liability for the third party. 6332D1 in this regard says it, as does a case of Heaton versus YRC from Minnesota, also mentions that. So essentially, she could comply with the levy. It wasn't a problem. They also reference Minnesota state law regarding tenancies at will that would cover this. And it just, the actual unqualified contractual right to receive property is a property right. And essentially, as long as they could determine, be capable of stating the determination requires the sum be capable of precise determination in the future. So we also had other cases, KMG Props versus IRS, essentially from the West District of Pennsylvania in 2009, United States versus Halsey from the Central District of Illinois of 86, which simply addressed month-to-month leases and included the levies attached to the obligations under those month-to-month leases. And, said essentially, you owed it all, right? And as far as the penalties go, it said, no, we don't believe that you reasonably tried to figure out the law. You simply were scamming everybody effectively. Again, your believability falls off. She claims she researched this position, and she reasonably arrived at it. But the problem is when you're caught in a lie by the court. Remember, the court caught her effectively lying by having to admit that the evidence she submitted, supposedly showing payment has been made to the IRS, those bank records weren't bank records. She blamed another employee that worked with her, who also worked, I guess it was a credit union, who also worked at the credit union, had helped her doctor the records. That's not a good thing to say. She had told, Mr. Olson, who was also in all these conversations, the IRS had been part of it with him, trying to find out where the rent money was. So she had told him about that. She never denied, any of that. She just said, oh, no, I paid the IRS. See? So her credibility was zero, and that makes it probably way more difficult for the court to believe that she actually seriously sat down and tried to find a legal reason, legal reasoning behind her position. She was simply trying to get out of paying any rent whatsoever. That makes you look bad, right? And that's how the guy the IRS was levying ended up on the IRS's side in this case. Okay, kind of an interesting case in that regard. So the key takeaways: levies attached to obligation exists at the time of the levy, but it can include a month-to-month lease. If you don't comply with the levy, your clients have to understand, if they get a levy, they don't comply with it, they are personally liable to the IRS. In a normal function, what happens there is that they get a levy and, they believe they believe their supplier's theory that, oh, the IRS, is totally being unfair. I've won, I'm going to win this case, etc. So they don't do it, which they think they have perfect right to. The IRS has no right to do this, quote unquote. Unfortunately, they do. They're going to have to write the check, and good luck getting it back from your supplier, right? You paid it to them, so that's your problem. So make sure your personal liability. And all property and rights to property is a very broad language. And you'll tell the client, assume everything's covered by it, unless you've gotten legal counsel that has told you clearly that this right here is not covered by the levy, and preferably the attorney in question has a really good malpractice policy in place, so there's something to back that up. And remember, the 50% penalty is mandatory if there's no reasonable cause shown. So you got to have reasonable cause for that. Ignoring a levy is dangerous, even in a case like this where you think, well, wait, she didn't pay any rent. She didn't take the money and send it on to the person that she'd been told not to send it to. No, she didn't. She didn't send it on to anybody. What really happened in this case is the IRS became her landlord. The IRS had a right to go after her for the money that her landlord would have had the right to go after her for. Right? She had done that, so tough luck. This has been the Current Tax Developments for March 10th of 2025. Current Tax Developments are brought to you by your state society of CPAs. You can find me online. Email eds@currentfortaxdevelopments.com. You can also find me on the Connect sites for Arizona, New Jersey, Minnesota, Illinois, Idaho, and Washington. I'll be around those looking at stuff. If you have questions there. Otherwise, it's been an interesting week. We had a lot of cases this week and the whole BOI thing. So we look forward to seeing what comes up next week, this coming week, and what we're going to have. Remember, we are heading to the deadlines a week from Monday on March 17th. It's not just St. Patrick's Day this year. It's also the deadlines for all of those pass-through entities that are calendar year. So make sure you've got your extensions in play or the returns filed by that time. So remember that. That's what you're going to spend this week doing, is getting ready for those extensions and making sure you've basically accounted for all of them. That's going to be the fun for this week. And we will see you all, though, next week with more current federal tax developments.